5 seconds to go. Start. The petitioners in the public interest litigation, the political party to which the minister belonged, issued a public censure, no action was taken officially against the minister. Stop. Therefore, the petitioner in one writ petition prayed, among other things, for a direction to the chief minister to frame a code of conduct for the ministers who have subscribed to the oath of office as prescribed by the constitution, with a further direction to the chief minister to take suitable action if any of the ministers failed to live up to the oath. Stop. The prayer in the second writ petition was for a direction to the concerned authorities to take action against the minister for his utterances. Stop. Para. Both the writ petitions were dismissed by a division bench of the Kerala High Court, on the ground that the prayer of the public interest writ petitioners were in the realm of moral values, and that the question whether the chief minister should frame a code of conduct for the ministers of his cabinet or not, is not within the domain of the court to decide. Stop. Therefore, challenging the said common order, the petitioner in one of those public interest writ petitions has come up with special leave petition diary number 34629 of 2017. Stop. Since the questions raised by the petitioner in the special leave petition overlapped with the questions raised in the writ petition, they have been tagged together. Stop. Para. We have heard Shri R. Venkataramani, Learned Attorney General for India, Miss Aparajita Singh, Learned Senior Counsel who assisted us as amicus curiae, Shri Kaliswaram Raj, Learned Counsel for the petitioner in the special leave petition, and Shri Ranjit B. Madad, Learned Counsel appearing for the person who sought to intervene in plead. Stop. Para. The Learned Attorney General for India submitted a preliminary note containing his submissions question-wise, which can be summed up as follows: Para. On question number 1, it is his submission that as a matter of constitutional principle, any addition, alteration or change in the norms or criteria for imposition of restrictions on any fundamental right has to come up through a legislative process. Stop. The restrictions already enumerated in clauses 2 and 6 of Article 19 have to be taken to be exhaustive. Stop. Therefore, the court cannot, under the guise of invoking any other fundamental right, such as the one in Article 21, impose restrictions not found in Article 19(2). Stop. Under the constitutional scheme, there can be no conflict between two different fundamental rights or freedoms. Stop. Para. The Constitution itself sets out the scheme of claims of fundamental rights against the state or its instrumentalities, and it has also enacted in respect of breaches or violations of fundamental rights by persons other than state or its instrumentalities. Stop. Any proposition, to add or insert subjects or matters in respect of which claims can be made against persons other than the state, would amount to constitutional change. Stop. The concept of state action propounded and applied in US constitutional law and the enactment of 42 US Code 1983 have to be seen in the context of peculiar state of affairs dealing with governmental and official immunities from legal proceedings. Stop. In view of specific provisions in Article 15(2), 17, 23 and 24 of the Indian Constitution, there may not be a strict need to take recourse to the law obtaining in the USA. Stop. Claims against persons other than the state, either through enacted law or otherwise, must be confined to constitutionally enacted subjects or matters. Stop.